Okay. Are both sides ready to bring in the jury?
No, we have argument.
Okay, argument as to what? The records I've ruled on, the 5 pages of notes I've ruled on, I said that I was gonna wait and hear argument as to why or why not the state should be allowed to get into these things on cross-examination if you all choose to, depending on what happens. So what other argument is there to hear now?
So, Judge, if I'm understanding correctly, your ruling was on those particular documents that you just referenced?
Correct.
That contain swastikas, that you do not believe that the prejudicial effect of those documents is outweighed by the probative value, is that correct?
Yes, why are we repeating what I've already said?
I'm asking for clarification because I need to make an argument for the record. I just
Okay.
want to make sure I understand.
That's my ruling, yes.
Okay. So in essence, you've now ruled on the state's SF-202 motion that they filed after the jury was sworn, admitting the swastikas into evidence. So at this time, I need to make the following record, and the defense will be moving for a mistrial. On January 22nd of 2021, the state of Florida filed a motion, SF-109. It was the state's motion for pretrial ruling on the admissibility of relevant evidence, specifically the hand-etched swastikas that were on the firearm that was left at the scene, the boots that were removed from Mr. Cruz, and a swastika magazine. The defense, on February 5th, 2021, filed a motion in opposition to that state's motion, SF-109. The state then filed another pleading. They included some etchings that were done on a school desk at Marjory, Stoneman, Douglas, and a drawing on the red backpack, which also included a swastika. And then the state filed another motion on other additional evidence that contained swastikas, specifically the Mossberg shotgun found out at Camp Mutiny. The defense, on March 19, 2021, filed D-146 in opposition to their new motion and incorporating all previous arguments. On February 25th of 2021, when we were having hearings on other matters, the defense once again brought up that there was a pending swastika motion that the court had not ruled on. That was again brought to the court's attention on July 13th of 2021.
Excuse me, I don't mean to interrupt you. Do you mean 21 or 22?
21. And then on August 17th, 2021, it was again brought up that the court had not ruled on that motion and the defense needed a ruling on the motion in order to formulate their defense and prepare their jury selection. We also brought it up again on August 27th of 2021. The court had not ruled on that motion. We also brought it up again in the third, when Mr. Marcus argued the third-party negligence motion on September 8th of 2021. The defense also brought it up that we did not have a ruling on this motion, which would impact our ability to prepare our mitigation presentation as well as our voir dire on September 21st of 2021. The court did not rule on that motion. Mr. Cruz pled in October of 2021, and at that time, the defense said that we were withdrawing our motions on the issues of identification, and that we asked that the court rule on SF-109 and the other motions the state had filed relating to that issue. The defense again brought this issue up before the court on October 26, 2021, and requested a ruling on the matter, as it would affect our ability and the decisions we would make in the presentation of the penalty phase in this case, as well as how we would proceed with jury selection. On October 29th of 2021, the state is now put on notice of our witnesses, and on November 3rd of 2021, we asked the court to again rule on all the evidence that had swastika information on it. When we were in court on November 21st of 2021, the swastika motion was not mentioned by the state, knowing that they had a pending motion. On December 7th, 2021, the swastika motion was once again not mentioned by the state, knowing that they had a pending motion. On December 21st of 2021, the state once again did not bring up the swastika motion, knowing it was pending. The same for January 11th and January 24th. We went to court again on February 10th, 2022. The swastika motion was not mentioned by the state. On March 18th, 2021, the swastika motion was not mentioned by the state. The defense requested at that hearing that all outstanding motions need to be heard before jury selection because we needed to know how the court's rulings would impede our presentation in the penalty phase as well as jury selection. The court did not rule on the motion. On March 30th of 2022, again, the swastika motion was not mentioned by the state. It was not mentioned again on April 1st, on April 5th, on April 6th, 2022. Knowing that this motion was pending, the court did not address it, nor did the state. And the following dates, we were also in court and the motion was not heard or addressed. April 27th, 2022, April 16th, 2022, May 23rd, 2002, May 25th, 2002, June 6th, 2002, June 7th, 2002, June 8th, 2002, on June 14th, 2022, Mrs. Curtis emailed Mr. Marcus and asked if the state intended to introduce the swastika evidence during trial because it would, this is not an email, but this is the ideology behind the email, because we needed to know how we were going to prepare our presentation of the penalty phase, as well as how we were going to conduct our jury selection. He told her that it was relevant because it supported antisocial personality disorder and borderline personality disorder of their experts. They also intended to call an expert at a hearing on that matter, and I believe that was the hearing with Dr. Brannon. Mrs. Curtis indicated that we needed to get a ruling on this matter before general voir dire. On June 14th, 2002, Mrs. Curtis advised me that the state intended to move forward with the swastikas, and we indicated that we needed a ruling from the court. The last day of capital voir dire, Melissa McNeil, myself, and Jeff, I approached Jeff Marcus and I also approached Michael Sachs, and I pointed out that there were several motions that needed to be heard before general voir dire, and this included the swastika motion and the motion in limine number 3, which had to deal with an unrelated matter. The defense mentions the need for a hearing on the swastika. On June 21st of 22, again, Ms. Curtis objects to starting general voir dire with outstanding motions pending, including the motions related to the swastikas. The defense requested that the court rule on the swastika motion. There was no comment from the state. On June 23rd, 2002, the court indicated I'll have that done by Monday morning, so be ready for a full day on Monday. I need to ask one thing before we leave. This is you asking the parties. With regards to the motion in limine regarding the swastika that was discovered after the incident, that hasn't been ruled on because I wasn't sure if the state is still attempting to admit the guns, which have the swastika hand-engraved on them. And if you are, that's fine. I need a hearing on the argument before both sides on the issue. And Mr. Marcus said, yes, we know that. I meant that as a motion for next week. And the court says, okay. And then I say to the court, Your Honor, and you say yes. I said, we brought this up because if the swastika was going to be admissible, we would have to discuss jury selection. And then I asked the judge for a ruling on the motion. After the jury was sworn, without the motion being heard on the swastika, the state filed an additional motion, SF-202, requesting a ruling on the admissibility of the swastika, as well as other inflammatory evidence not previously mentioned by the state. The court has not ruled on that motion. The defense at that point made an argument that the presentation of our penalty phase would be impeded, or perhaps we would have had a different strategy as to the presentation of our evidence. And also, our voir dire would have been different because we would have asked each individual prospective juror what their feelings were about swastikas, and other anti-Semitic comments that Mr. Cruz has made through the documentation, either things that he has drawn, things that he has said, or things that other people have heard him say. So, in essence, by allowing the swastikas to come in through carry on, the court has ruled on SF-202. The court's failure to rule on this motion prior to the swearing of the jury and during the pendency of this trial is in fact an abuse of discretion by not ruling on it, because the defense has chosen not to do certain things without this ruling. An order granting a mistrial is required only when the error upon which it rests is so prejudicial that the entire trial, that it interferes with the defendant's fair trial rights. I'm citing Smith versus State at 866, Southern Section 51, and Overton at 801, Southern Second 877. Over defense objection, the state has admitted into evidence photos of the crime scene showing blood spatter, books about the Holocaust. The state also offered testimony about murders that occurred in the Holocaust studies classrooms. They were making a very thinly veiled attempt to compare Nick to the Nazis. Doing so violates the following constitutional rights. Due process. Florida Constitution.
I'm sorry, when did they do that?
During their case in chief.
And by how? By showing the actual crime scene photos?
Right, and we filed pretrial motions telling them, requesting that the court not reference that room as a Holocaust room, and it was in fact referenced as a Holocaust room. We
Okay,
also asked
I understand what you're saying. Go ahead.
also violates fair trial rights pursuant to Florida Constitution, Article 1, Section 19, U.S. Constitutional Amendment 6, Section 14, U.S. Constitution's Amendment 6 and 14, also the 8th Amendment, prohibition against cruel and unusual punishment, as well as the 14th Amendment, which is equal protection. When Mr. Marcus moved into evidence yesterday, I believe, or it might have been the day before, through Jessica Clark, which was the disciplinary forms, the DMS forms, he, in fact, himself redacted the references to swastika because the court had not ruled on the motion. So at this point, the defense respectfully moves for a mistrial because we believe that Mr. Cruz's fundamental constitutional rights to due process and a fair trial have been violated by this court and by the state of Florida.
May I respond?
You may.
So initially, the defense has clearly laid out their knowledge that there was a pending motion. They knew the entire time that swastikas was a pending motion. It's certainly not unusual for a court to defer ruling on motions in limine that involve a lot of evidentiary support and determination. It's very difficult, we understand, and attorneys ask for motions in limine because we're trying to understand what's going to come into evidence later on. But from a court perspective, it's also very difficult to understand the context of how evidence comes in. Now, Ms. McNeil has blended swastika to all the various swastikas that are involved in this case. So the state's initial motion about the swastika evidence was the magazine that was in the weapon, in the AR-15, which had swastikas on both sides, which were not shown to the jury. They were covered with tape, so the jury could not see those swastikas. And the state intended on its case in chief to also introduce the swastika on the boot. The state was not indicating that it was going to use other swastikas unless it became a reason to during the course of the case. So that's what those motions were about. They were about those swastikas. The state has never mentioned the is Ms. Jan still hearing this?
She's muted, Mr. Marcus.
She can, I
Please
know she can't,
let me answer, please. Ian, she's muted, correct?
she can't hear
She
it.
cannot hear.
Okay, thank you. So the Miss Jan material, the state never mentioned. It has not come up once in this case from the state side that we were seeking to introduce the swastikas contained in the writings of Miss Jan. That wasn't anything that we mentioned in any motion that we were going to move into evidence. The case is entirely different now from pretrial when the state did not seek to make the swastikas a feature of the case. We were addressing the scene itself and his capture. If something came up, then it may be relevant. We expected, and that's why we filed a motion, that it would become relevant in rebuttal evidence for the state. The defense has already opened the door to mental health testimony. The state, as the court recalls, heard from Dr. Brannon that the diagnosis is going to be antisocial personality disorder, and that a feature of that is hatred, and a swastika is evidence of that hatred. The door is opened by the defense by putting on their mental health testimony. It's also been opened by things such as that he was bullied, and for a different reason. The swastika it's a hatred symbol, and it, by virtue of it, symbolizes that you're trying to intimidate somebody, as well as, the defense has no problem with the N-word coming in, which is arguably the same. It's so bad. They're equally as terrible, but they have no problem with that coming in. The defense did voir dire and did bring up the bad things of the defendant. They even brought up animal abuse in their voir dire. They brought up everything conceivable about it. They cannot complain that they did not know that swastika could be a part of this case. Whatever decision they made, that was their strategy. But the one thing that we have total silence on from the defense is that if the court, if the court was not ruling, they have a remedy, and that is mandamus. They never took mandamus to the 4th DCA. They know how to do that. They've done that before. There's no reason that they could not have tried to compel the court to rule on it if it was a matter that they can compel. They can't come in here and say, we had a conversation with the state and they said this, and this came up several times. All that shows is that they were well aware of this issue, and they chose not to pursue it. It was their strategy, and we're at the state that we're at, where if they want to introduce this testimony and the court has already ruled, that's their decision. Thank you, Your Honor.
Great.
Just briefly, Your Honor, the defense repeatedly, and the record will stand for itself.
Okay, let the record stand for itself then.
Requested, I'm rebutting what Mr. Marcus is saying, that the court rule on this matter, because we knew how important it was to how we would proceed with our penalty phase and how we would conduct our jury selection. We are not complaining. We are advocating for our client. That's why we continue to bring this up to the court's attention. And the court did not rule pre-trial, and they did not rule before the presentation of the state's evidence. The reason why the swastika was covered up on the firearm is because I requested that it be covered up because the court had not ruled on the motion. And the pleadings that the state had filed clearly illustrate that they are not just talking about the gun. They were trying to bring in the stuff from Camp Mutiny. They were trying to bring in the stuff from the desk. They were trying to bring in the stuff from the backpack. And because of that, pull the motions up then. And because of that,
I'm sorry, who are you talking to?
to Ms. Chiappoli.
Okay,
who's
please
saying
don't-
that the
don't-
motions
do
don't
not
have-
talk.
One at a time.
No, I'm going now. Don't talk to each other back and forth. It's unprofessional. This is not happening.
Okay, I apologize. But the point-
Ms. Giappone, if you were talking, that goes to you
I
too.
the word, Your Honor.
Do not talk directly to the state. State, do not engage. This is getting out of hand. It got out of hand yesterday and it's not happening again today. If you all want to speak, you speak through the court. Everyone knows that. That goes to both sides.
Yes.
Wrap it up, please.
The point is this, the defense is now put in a position, because we were not able to voir dire on this issue, and because the court has not ruled on either 190 or 202, that we are forced to introduce very inflammatory prejudicial evidence against our own client. And because of that, we move for a mistrial. This is not a strategic decision. This is because we have told this jury that we will be honest with them, which is one of the reasons why we repeatedly asked the court to rule on these particular issues.
Okay.
I have no other matters for the court, and I appreciate you giving me the patience to make my record.
All right. The swastikas to this point have not become an issue. The state has indicated in their motion that it would become an issue in rebuttal. In other words, that is where they wanted to bring it in, depending on the testimony. And the court has an obligation to hear the testimony before I can decide whether or not it is relevant and whether or not the door has been opened. Now, you can't make something an issue and then expect the court to prevent the opposing party from their right to confront the evidence. And as far as this, what I would call an anticipatory mistrial, as to evidence that may or may not come in on cross-examination, or evidence that you have a choice of whether or not you can put in, or through a witness that you have a choice as to whether or not you can call, is disingenuous. It's denied. Your motion for mistrial is denied. My ruling remains the same. Let's bring in the jury.
I'm sorry, can I have 2 minutes to run out these restrooms really fast?
Sure, 2 minutes.
Okay.
And then we're gonna go all the way from 10:42 until lunchtime. So if anyone else needs to use the restroom, please do so now.